Okay, how these things tend to happen. Let me put on some more light. And I also need to pour another libation to keep this energy right. And here, warriors, guardians, ancestors, angels, I command thee to bring all positive energy, remove all negative forces, known and unknown. Anyone that's out here to bring me harm, go to them now and snap their necks like a charm. So it is, so it is, so it is, so it is. Ori, guardians, warriors, ancestors, angels, I command thee, for all those that are out here messing with my communications, aiming to do me harm, go to them now and snap their necks like a charm. So it is, so it is, and so it is. Ori, guardians, warriors, ancestors, angels, I command thee, for all those that are tampering with my communications, aiming to do me harm, go to them now and snap their necks like a charm. So it is. Ooh, y'all see the orb? So it is, so it is, and so it is. I want to start this off right. Ooh, look at the orb. Wow. All right. They in the house. I'm going to pour libations before I start this second video. This is my second video. I abruptly got cut off, so had to clear some energy. And we want to always give thanks and pour libations for the great mothers. Nanny, Ashe. Harriet Stanley, Ashe. Aunt Vi, Ashe. Empress Verdiasi. Mother Washita, Ashe. Empress Khalifa, Ashe. Queen Charlotte, Ashe. Mama Chimbi, Ashe. Queen Sheba. Martha the Dominator, Ashe. Oya, Ashe. Mama Wata, Ashe. Divine Mother Nature, Ashe. All ancient divine mothers of creation, Ashe. All ancient rulers of the earth, Ashe. All divine mothers that brought forth the divine seeds, Ashe. All great warrior goddesses, known and unknown, Ashe. 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 All right, getting back into y'all that missed the first part will have to go back later and watch. I'm just gonna continue where I left off. All right. Basically, I'm decoding the word frivolous and also the end. Let's see, informa proprius applications, right? So basically, a brother sent me his case. He asked me to decode the recommendation that the court had made, and basically they told him he failed to show basis for the court to exercise jurisdiction. And so this is a part of the decoding of these court memorandums and recommendations. So basically, if you put your status on the record, right, and then we go to them and ask them for something, you have already let them know your status dictates your jurisdiction, and you have already been granted immunity by law from prosecution. So that's why they call things frivolous under their statutes. This is the statute that they use. Mark my words, take it down, write it down, go search it and research it for yourself. They use this one right here. Title 28, 1915, E2. They use one or more of these statutes right here. That's Title 28 USC 1915 E2. Okay. Most times they will use this. This one is frivolous, or it fails to state a claim for which relief may be granted, or you're seeking relief against a defendant who is immune from such relief. And that can be used the other way around as well. You are a plaintiff seeking relief from an entity that has no jurisdiction and from which you are immune. All right. Now go back. Here's the North Carolina statute that I use. This will dismiss any and everything. You can use this with the notice of removal, but just to get rid of it, instead of removing it and wasting your time on something that they cannot adjudicate for you anyway, you could just use this to quash it. All right. This is the statute for North Carolina that I love to use in combination with the federal statutes that I'm going to show you in the affidavits that I use. All right. So this right here in the North Carolina statute 15A-954, motions to dismiss based upon the statute alleged to have been violated is unconstitutional and improperly applied to the defendant. 2, the statute of limitations has run. 3, the defendant has been denied a speedy trial required by the Constitution of the United States and of North Carolina. You can find these same statutes in your state. 4, the defendant's constitutional rights have been flagrantly violated. And this is a term used for the DAs, judges, and district attorneys, regular attorneys, and all of them. Flagrantly violated. And there is such irreparable prejudice to the defendant's preparation of his or her case that there is no remedy but to dismiss the prosecution. That's another good one that I have used. 5, the defendant has previously been placed in jeopardy of the same offense. Like they tried to charge me 3 different times for the same thing with that Piper Glen house in a 3-week period. 6, the defendant has previously been charged with the same offense in another North Carolina court of competent jurisdiction, and the criminal pleading charging the offense is still pending and valid. 7, an issue of fact or law essential to the successful prosecution has been previously adjudicated. That's another one that I have used. 8, the court has no jurisdiction of the offense charged. Okay, a court has to have both subject matter and persona jurisdiction. So if the court has no jurisdiction over you, it has no jurisdiction over your offenses that may be allegated towards you. Okay, here's my favorite, number 9, that I use in my affidavits to basically shut them down. The defendant has been granted immunity by law from prosecution. All right. So let me show you how I use that. Pull up my affidavits. Okay, this is one that I gave to the state regarding a driver's license that they tried to pin on me, that I never applied or contracted with the state of North Carolina for a driver's license. But they play their tricks and they put us under duress adversely. I always do things as an affidavit. And this is a part of my package and is affirmed by verified statement. I let them know the state of North Carolina, city of Charlotte, Mecklenburg, county of Mecklenburg, is in violation of law of nations, United Nations rights of indigenous peoples, and this is actual, lawful, and constructive notice from the living soul. Make the distinction. Back in the day, if you read some of the letters and notices from our ancestors, they would always put LS at the end of their names, distinguishing them from the corporate status. So that's a little trick that I do sometimes. Distinguishing myself, letting them know that this is the living soul presenting my affidavit. And I am of indigenous status. It has been over 10 years since the first notice was received by the state of North Carolina, Secretary of North Carolina, Treasurer of North Carolina, Attorney General of North Carolina, Governor of North Carolina, City of Charlotte. I don't leave nobody out. County of Mecklenburg, of the secured parties status. Now, a staple of law for over 7 years, that Ninti El Bey and all of my names and copyrights and derivatives thereof. That's why I put parties, more than one. All of my names and variations are included, because I own all of them. Let me make one point to y'all. Everything moving in commerce belongs to us. I don't care if you have a social security number and you don't have and you don't want it, or you gave it back, or whatever. Let me tell you something. Everything that's moving in commerce belongs to you. If you want to use it, use it. If you don't. Just know that that's your choice. And it's all yours for the taking, because your ancestors said so. So if you want to use it, you use it to your benefit and make them work for you, but know how to stay out of their contracts. All right. And I also let them know I am not, here's the main thing right here. I am freehold by inheritance and birthright. Jurisdiction, nationality, and status is immune to any and all claims brought by the U.S. Corporation or any states of the Union, pursuant to North Carolina Statute, Chapter 52, Section 15A-954-9. The jurisdiction for her matters do not lie within any Admiralty maritime court system. Operating on water. Yeah, I put it right in their face. I know you on water. You're fake, you're fiction, and you do not apply to me. I am attached to the land, period. And see, all of this can be done with one piece of paper. And they be looking real crazy when they get it too. Like, what in the world? Who is this? Who is this person? How does she know this? You know, you got to give it to them like you the boss. Because you are. You are the landlords of the land. They have to answer to you. They're sitting their corporate bodies and fiction buildings on top of your land. So we look real crazy going to them, asking them for anything. That's why we got to hurry up and get our stuff together, because we're in limbo. They really cannot adjudicate for us. All right. So I go on to say in this affidavit, Ninti El Bey is not a party to any contracts by the state of North Carolina or any other state that would bind or waive her sovereign immunity at law. That is a lawful term, sovereign immunity, which they try to steer you away from by making it a bad thing. We are not sovereign citizens, but there is a term for us at law. Okay, I just showed y'all the federal statutes that they know that you are immune at law. That's it's also called crown immunity. All right. The state of Georgia was noticed. Okay, I was responding to a fraudulent act that was committed against me in Georgia, spearheaded by some rogue federal officers in North Carolina. When they came in the house on me, that next morning I left and I was going to driving through Georgia, and I didn't have a plate on my car because I was going to sell the car. They had put out a bulletin on me and the car. So, of course, I was pulled over by Georgia. They accosted me, put me out in the middle of nowhere. And so after I finished that incident, several months later, the state of North Carolina is contacting me for the state of Georgia, talking about a ticket. So I had to shut them down. And that's why I'm talking about the state of Georgia. The state of Georgia was noticed of this fact 90 days prior to sending claim to the state of North Carolina, wherefore are jointly and severally liable to the secured party creditor. I'm letting them know I'm the secured party creditor for the violations of conversion of property. They took my car. I had to spend $400 and some to get it back. Simulation of process. Y'all can look up those terms. Identity theft. Copyright infringement. Additionally, I'll give them a history lesson. Additionally, violation of the law of nations, United Nations rights of indigenous peoples, and actual lawful and constructive notice. Notices from Living Soul Ninti El Bey, L.S. of her indigenous status. Ninti El Bey has never waived her sovereign rights. Period. Ninti El Bey has never applied for a privilege to drive a motor vehicle in the state of North Carolina. North Carolina's constituents have converted an identification card into a license. Ninti El Bey is not a party to any contracts of the state of North Carolina or any other state that would bind or waive her sovereign rights. I like to repeat stuff like 3 times too, by the way. Okay, where am I at? All right. Her sovereign immunity at law. Driver's license implied by the state is a way to unlawfully impede Ninti El Bey's locomotion. All adhesive contracts regarding traffic matters have been satisfied and appeared to by special visitation. Driving records must be abated and made clear of all failures to appear. This is one of the devices that the state is using to falsely impede Ninti El Bey's movement in commerce on the land in which she has aboriginal title to and is considered part and parcel thereof. The state of North Carolina efforts to deprive rights under the color of law, defame the character and the name of Ninti El Bey has already cost. I'm playing with this camera. The state of North Carolina, 101,006,000. As indicated on the state's ledger report for settlements since 2011. This essentially let me read without this. This essentially means that Congress has the final words as to the scope of tribal sovereignty and the powers that tribes are able to exercise. One exception to this general rule is the doctrine of tribal sovereign immunity. Tribal sovereign immunity is part of federal common law. It was not created by any statute or act of Congress. That tells you right there. If no act could create it, if Congress could not create it, then it's greater than them. So I use tribal, it's something called tribal sovereign immunity, and crown immunity. Either way, like I said, every term, every benefit that's being used in commerce is inherently granted to us. Just because they haven't specifically made any laws or statutes based on the Moors having immunity, so on and so forth, anything moving on in Congress, they have laws or benefits, I should say. Let's say benefits. They have benefits to those granted in Congress. Anything granted to them is granted to us. We attach to the land. They have benefits granted to judges. They have benefits granted to so-called Indians. Anything moving in commerce that anybody is benefiting from, and it's on the books, it's inherently granted to the Moors. So I don't care if it says Boo Boo the Fool, Indian, Lulu, or whatever. If it's a benefit, I'm first in line for it. Okay, let's not get it twisted on these facts. Like I said, everything moving in commerce, if they giving out benefits, You first in line. First in time is first in line. That's not saying I'm calling myself an Indian. That's not saying I'm calling myself a congressional member, or I'm calling myself anything other than what I am. But what I am saying is that any benefits moving in commerce on my land, I can partake in. That's what I'm saying. And I do just that, and in the statute or otherwise. So all of these statutes, case law statutes, this one right here is of the Moors. But we don't know that because most of us don't read. Turner versus United States. That's a tunica. They're talking about tribal sovereign immunity, where Turner versus United States won. I got about 30 of these in here in this affidavit, dictating what is the course of action taken for a person of our status with sovereign immunity, period. These Supreme Court cases cannot be overturned. They're dealing with tribes, Indian tribes, so on and so forth, Choctaw, Chickasaw, Washita, like I said, Tunica, which we know that these are our original tribes. So in all our doings, we have to know how to present ourselves and how to not get into contract with them. These are ways to use whatever benefit that is being granted to any so-called Indian shall be granted to us until we put our stuff back on the books the way it should be. Once again, anything moving in commerce and they giving out benefits, first in time is first in line. That's us. So I don't care what they calling it. Put in an affidavit and let them know your status. You are an Aboriginal Moor and you coming under this case law. You have crown immunity. You have tribal immunity. You have sovereign immunity. You see what I'm saying? Use what they already have on the books to walk through the door. It's yours anyway. So that's how I do that. And so it's just so many case laws. They know that we are immune. So that's why it's like an oxymoron when we put our status on the record and then ask them for something. We are superior to them. We are superior to federal court. We are superior to Supreme Court. All of these are corporate fictions and they utilize U.S. codes. They are not within the law. You are the only one that can execute law. That's why when people was talking about me with that house, so on and so forth, which I did not use my status, by the way, to even get the house. I've been in real estate since the age of 19 and been getting houses creatively since that time. I'm 44. So who's walking in whose lane? They came in my lane and got ran over and continuing to get ran over because they shouldn't have violated me. But yeah, I didn't even use my status to get that house. It was only until they kept bringing it out in the media because of my name and trying to defame the character of the Moors that I had to come out with a response. And I said, if you want to talk turkey and be technical, anything moving on this land has no greater claim than that of Ninti El Bey. Since you want to talk about me, here you go. That's how that happened. But other than that, I didn't even have to use my status. I have enough intellect and licenses in real estate to get any house that I want with pure knowledge. The bank did not dispute me. Why are these rogue real estate agents coming after me? Because they didn't like the neighborhood I was in. And then the so-called government here in North Carolina have a political agenda against the Moorish nation. So they felt that was a perfect opportunity to defame the character of the Moors. It really didn't have anything to do with me. They knew at law they could not touch me, which all of the court session videos will show you that. They converted a civil matter into a criminal matter that should not have made the news and international news. It's just ridiculous, but we're not supposed to know these things. So anyway, crown immunity. It can also be called crown immunity. Crown immunity is a legal doctrine by which the sovereign, they have to inject themselves in there, or state cannot commit a legal wrong. They cannot hide up under this. The state and judges and all of them cannot hide. United States Corporation cannot hide anymore under immunity. Says so by the Clearfield Doctrine. As long as they're using Federal Reserve notes, in which they are, the Clearfield Doctrine tells us that they do not have immunity, as they try to make us believe they cannot be sued. That's not true. Anyway, we have, under the legal doctrine, their legal doctrine, sovereign immunity, and it cannot commit a legal wrong and is immune from civil suit or criminal prosecution. In constitutional monarchies, the sovereign is the historical origin of the authority which creates the courts. Thus, the courts had no power to compel the sovereign to be bound by the courts, as they were created by the sovereign for the protection of his or her subjects. Do y'all hear how powerful that is? And I use every bit of those words in everything that I do. The matters of Ninti El Bey must be turned over to her own government, not the state corporation, U.S. Corp, and or courtrooms. Pursuant to North Carolina Statute 52, Section 15A-954-9, the defendant has been granted immunity by law from prosecution. And I let them know my title. Yes, I do. So we have to get in the driver's seat more and learn how to utilize these all modalities of law. Everything moving on in commerce right now is moving under the International Commercial Code, Uniform Commercial Code, which is international law. And everything that has to do with our commerce, we need to learn it. I don't care what you heard, but you can shut them down with this too. I let them know my filings where I have claimed all of my chattel paper property. They don't own nothing of mine. They cannot use it. It's me, and they cannot profit off of my birth certificate, my names, my numbers, or any derivatives thereof. Is filed within various filings in the region of Kentucky, state of Kentucky, Commonwealth, and that's indefinite. So me and my children's birth certificates, names, and numbers are all claimed already. So basically everything boils down to commerce. They cannot make any money off of me. Aside from, first is my status. I already shut them down. So, but if they want to keep playing the commerce game and use my straw man under my birth certificate, I got them on that too. They can't use none of my stuff. This claim is presented to you pursuant to the provisions of Section 442 and 1330 of the Consolidated Statutes of North Carolina, to be audited and allowed. There's also, okay, here's another one that I used on them that they like to use on us. Wherefore, Nicholas Tennyson, Pat McCrory, and Roy Cooper of North Carolina are presenting claims that are meritless in legal theory or is founded upon clearly baseless factual contentions, such as fantastic or delusional scenarios. Netzik versus Williams. Now, I use that against them. And I sign it, secure party creditor. And there's that. There's the affidavit. And I'm going to show you, they got that, they have that in this memorandum and opinion as well. This memorandum and opinion from the United States magistrate judge is use that same case law. There you go, right there. I just turn around and use it on them. But they gave the definition of the word frivolous. For those of y'all that weren't here for the first video, I basically decoded how they use the word frivolous and how it's being applied. All right, let me answer some questions. Islam says, when is the best time to contact me? You can call me anytime, bro. I emailed you. Anybody have any other questions before I close on this lecture? Send them to me now so that I can answer them. That's right. Any commerce that is a benefit is our inherent right. Ashe. Islam, my brother. Abdul Kareem El Bey. Mikael Shabazz, any questions? Abdul Kareem El Bey, any questions? Jason Huff, any questions? Robin Hood, any questions? Robin Hood. Charles Howard Bay, any questions before I leave and close out? I'm going to come back with another video on some spiritual things that have been placed upon my heart. I'm going to take a quick break. And I'll come back with that frivolous. Can you point out what part is frivolous and ambiguous to you? I'll inbox you, sis, about owning the chattel paper. Yeah, look at the first video, bro. William Amalong Bay. I posted the decoding of the word frivolous. It's basically, when they use it, they are asking, or they are telling you that you have not given what you're saying lacks an arguable basis either in law or in fact, right? So that's, once you give them your status on the record and let them know your status in your because status dictates jurisdiction automatically. And in order for them to rule, they have to have jurisdiction over the subject matter and the persona. If they know up front at the beginning they don't have jurisdiction over the persona, that automatically takes them out the game. So for us to keep coming, asking them for something is frivolous, because you have already, is nothing to talk about. There's no arguable basis in law law or for them to move on at that point. You know, so that's basically what it is. So you see how I use these statutes and these case laws back on them. So I use that Netwitz versus Williams in this affidavit. Let me go through this other affidavit real quick and then I'm going to close out. So that's the affidavit regarding the driver's license. And the reason why it's meritless that they even brought a claim against me, because they already have all of my stuff on the record. They already have all of my stuff on the record. And they know this. So in my closing of this particular affidavit, I let them know what they were saying at law. And they know this case law very well. Netzvik versus Williams, 490 U.S. 319, 327-28, 1989. So by them knowing my status, having it on the record, and still bringing claims against me, I mean, it's ridiculous. So I just threw that back on them. You know, your claims that are being presented are meritless in legal theory or is founded upon clearly baseless factual contentions, such as fantastic or delusional scenarios. And that's the Netzvik versus Williams. They know exactly where I'm coming from with that. And so that's the affidavit. And in every affidavit, because technically using a notary puts you back into the court system and their jurisdiction, so on and so forth. So this is one way how to stay out of their contracts. I give them a disclaimer every time. And I let them know the use of a notary is not an entrance or acquiescence into a foreign jurisdiction, only for verification of identity. See, this is how you have to present yourself, and going in and out, and it's like always reserving your rights, but at the same time they requiring you to do these certain things because they put us in duress under their coercion. So we have to at times respond. So this is the way that I'm showing you how I've been able to respond without getting back into contract. And so if you have to get into contract, if you got to use a state ID or something is pressing upon you and they're forcing you to do something, you can always do it and reserve your rights and reserving your status by, you know, altering the contract. You are the creditor. You can alter the contract as you see fit. All right, so that's a way of using a notary without getting back into contract, and you can do that with anything. But dealing with court, I don't even sign anything dealing with them. I'm not signing your pretrial. I'm not signing your probation. I'm not doing any of that because they already know who I am on record. But their aim, and they have an artful way of getting you back into contract. I rest upon this right here. Crown immunity, sovereign immunity. We are under a constitutional monarchy once again, and I stand on that proclamation of the Aborigine Moors of Amexem filed at the Library of Congress. So they can't at law touch you. So that's why I'm going into the next video talking about the spiritual aspects of how we have to incorporate a holistic approach to protecting ourselves. Because when once they were not able to put me up under the jail and I was able to come out unscathed, that was for them the worst thing that could happen, because now look what I'm doing. I'm waking y'all up. And so they come at me every day on a spiritual tip. And if you are not in tune, you will succumb to bad luck, so-called bad luck, depression. Some people have freak accidents and they die. You know, we've had some things happen recently, but these people are manipulating the sciences that they've hidden from us. They're using our ancient knowledge, ancient sciences against us, and we don't even know it's coming. So if you, that's the art of war right there. If you don't know you have an enemy coming after you, you don't have nothing to oppose. So that's how they've been winning. But just know that they coming since the Christian Crusades and the Rosicrucian Crusades. They've been coming at us in the name of religion and having spiritual prayers and rituals against us as Moors and the children of the Most High God, Israel, the 13 tribes of Judah, preventing us to not come together. Once again, all of this stuff is prophecy being lived out. It was given to me by divine spiritual enlightenment, a lot of things regarding the lost books. So I'll talk about that on the next video, because once you beat them at law, you're going up in levels. Now you're going up in levels that you're going to have to learn how to swim up there too. So they see that we climbing and we getting all of our levels back of knowledge and overstanding. So the next thing they do is the spiritual thing. So this is this is the clincher on everything we just saw. I showed you where the federal judges' opinion and memorandum let you know that you immune, gave you that statute. I showed you where your claims are frivolous when given to them because they don't have jurisdiction. And I've showed you how I used the term immunity and several, probably about 30 case laws dealing with indigenous peoples and Moors regarding our crown immunity, which we have sovereign immunity at law. Because for one, they're not using law. The only ones that can fully execute law in our proper person and propria persona is the heirs to the land. And all judges know this, all courts know this, and all attorneys know this. That's why they have secret societies to keep this from you. And that's been the biggest secret all of these years, for the last at least 230 years. Okay? Congress knows this. Connection is going in and out. Yeah, you start talking some heavy stuff, you know what happens. But anyway, so anyway, let me go through this one real quick. This is another affidavit that I use that's very helpful, that you all can benefit from. This is an affidavit of immunity, just solidifying everything I just went through. And in North was one that I removed to the higher court. Affidavits on hearing for removal. When removal ordered, no action, civil or criminal, shall be removed unless the affidavit sets forth particularly and in detail the ground of the application. So a lot of Moors that are moving cases up and doing notice of removal, you have to also incorporate an affidavit. And this is something that we might be missing if you removing it up. But I also showed you how to just quash the case right then and there, because moving it all around, they still don't have jurisdiction, and they just going to give you the runaround. It can be used for good experience, but if I had to go through it, why should you? I'm just telling you how to save some time. Okay, this is regarding any and all court presentations wherein the state and federal United States district, superior, and federal courts. This is me noticing all of them in this affidavit. The states, municipalities, law enforcement, court officers, notice to the principal is notice to the agent. Notice to the agent is notice to the principal. Now comes, and you must say it like that. Now comes. You are coming to them. You are coming to them. You're not presenting or re-presenting anything. You are coming as your living soul. Executor, you can use terms like administrator or executrix if you're a woman. Executor is, you can use that interchangeably. So I am coming as the living soul, executor of her own estate, taking first lien right, ownership over all her children's chattel paper property, names and numbers. I remember when they came and took all, unlawfully arrested me on false warrants and came in the house, took all of my stuff out of the house. I got word that they were going to try to take my children. This how this beast think they can slam dunk us. So years ago, I had already secured my children, and my children are under the school records. They are indigenous. It's not their business if I'm at. The brother asks, now what if they ask you to show proof of being an executor? That's your private business. Hale versus Hinkle. Go look that up and bring it back and tell me the answer, what it says. That's case law. Hale versus Hinkle, 1906. You don't have the right or the duty to divulge your private business to anyone. If I say I'm the executor, I'm the executor. That's it. And I said that in court one time, and the judge sat back in his chair and he couldn't say nothing but look at the attorney and say, listen, so what do you want to do? It's time to stop playing. She knows her stuff, and we're going to waste a lot of time going in circles. So what you want to do? That's how you handle that. All right. So I let them know I got my children's chattel paper, property, names, and numbers cannot be now or in the future considered a minor. That's the main thing we're dealing with right now. And in all of those doings and contracts, I let them know in no uncertain terms am I considered a minor. All derivatives thereof, contracts created knowingly and unknowingly from the time of creation, are owned by Ninti El Bey. Further standing, Ninti El Bey is a member at this time, Yamasee tribe, Moors National with sovereign immunity. The jurisdiction of her matters does not lie within any Admiralty Maritime Court operating on water. Some of this verbiage was in the other affidavit. Ninti El Bey is not a party to any contracts of the state, and I'm never binding or waiving my sovereign immunity at law. All adhesive contracts regarding matters have been satisfied and appeared to by special visitation.